Hi everyone, this is Nicole Atkinson along with Lisa Smith, and we will be presenting to you today information about HIPAA and its relationship to research. This module discusses data protection requirements for human subject research that derive from the Health Insurance Portability and Accountability Act, better known as HIPAA. HIPAA's data-focused protections, which took effect starting in 2003, works together with the Common Rule and U.S. Food and Drug Administration, again better known as FDA. HIPAA's regulatory scope and protection applies to protected health information, PHI, covers individually identifiable health information, applies to covered entities and business associates, and privacy rule and security rule govern protections. What kind of users and uses are covered? Well, let's take a look. Covered entities. Examples include healthcare providers and business associates. Researchers may be part of the workforce of a covered entity, or they, meaning researchers, may be covered entities themselves if they are also healthcare providers. HIPAA's rule on use and disclosure are generally purpose-based. That is, the intended use sets the rules more than the type of data itself. What constitutes research? Like the Common Rule, HIPAA defines research as a systematic investigation, including research development, testing, and evaluation, designed to develop and contribute to generalizable knowledge. Note that some kinds of investigative activities that use patient data are excluded in this definition. One example of this includes activities intended for quality assessment and improvement, like outcomes evaluation and development of clinical guidelines or protocols, can fall under healthcare operations, provided the primary aim is not obtaining generalizable knowledge. Who enforces the HIPAA research protections? A covered entity may choose to rely on an IRB, we are all too familiar with IRBs now, to assess compliance with both FDA regulations and Common Rule requirements and HIPAA research requirements. Alternatively, HIPAA provides that covered entities may create a privacy board to handle some research-related issues, notably determinations about eligibility for waivers, alterations, and exemptions from authorization process. What are HIPAA research-related rules? If the data in question meet the definition of PHI and are being used for purposes that fall within HIPAA's definition of research, HIPAA generally requires explicit written authorization, consent, from the data subject for research uses. However, HIPAA allows for research-related access to individuals' identifiable health data without authorization under certain circumstances, which include the research involves only minimal risk, the research is used solely for activities preparatory to research, only deceased individual information is used, and last, research where all legal permissions were in place before HIPAA took effect. Waivers of alterations of authorization requirement due to minimal risk. An organization's IRB or privacy board, and in some organizations a designated privacy official, may determine that a waiver or alteration of the authorization requirement is appropriate. The conditions are modeled on the criteria for a waiver of informed consent in the Common Rule. One element of this waiver includes adequate written assurances that the PHI will not be reused or disclosed to any other individual or entity, except as required by law for authorized oversight of the research project or for other research for which the use or disclosure of PHI would be permitted by HIPAA. Activities preparatory to research, decedent's information exception. in which there are two, where the PHI will be used solely for reviews preparatory to research, for example, for protocol development or identifying potential subjects and will not leave the covered entity. And number two, where the PHI refers solely to deceased individuals, the covered entity may ask for documentation of death of all data subjects. De-identified data. A researcher may use fully de-identified health data without any authorization from individual data subjects. As the name implies, de-identified information must have all direct and indirect identifiers removed to eliminate or at least make highly improbable re-identification using statistical techniques. De-identified information is no longer considered PHI because by definition it is no longer individually identifiable.
I appreciate you getting us started, Nicole. So I am going to start my portion of the presentation with limited data sets. Okay, so sometimes fully de-identifying data just isn't realistic for the kind of research we need to do. In those cases, HIPAA provides another option, a limited data set, or also known as LDS. With an LDS, all direct identifiers are removed, but some indirect details may remain because they're important for the analysis. Since there's still some risk, researchers must sign a data use agreement. That agreement lays out exactly how the data can be used and who's allowed to see it. And it makes clear that no one may identify the data or contact the individuals behind it. It's meant to strike a balance, protecting people's privacy while still allowing meaningful research to happen. The minimum necessary rule states that when PHI is used without full authorization, researchers should access only the minimum information needed for the study. A covered entity can rely on the researcher's justification or an IRB or privacy board's review to confirm that the standard is met. Once a participant signs an authorization, this rule no longer applies because they've already agreed to the use. People have the right to know when their PHI has been shared outside of the organization. Internal access doesn't count as a disclosure, but anything sent externally must be tracked for 6 years. Even when HIPAA doesn't require internal logs, many organizations still expect researchers to keep records as an added security measure. When we use PHI for research and none of the exceptions apply, HIPAA requires a written authorization. That document needs to spell out exactly what information will be used, who's using or sharing it, and why. It also has to include an expiration date or event, such as end of study. Most places combine this with the informed consent form to keep things simple for participants. And honestly, it saves everyone from signing yet another piece of paper. Your IRB templates are your best friend here because they make sure nothing important gets missed. Participants can also change their mind. They're allowed to revoke their authorization at any time as long as they put it in writing. That said, the revocation doesn't undo anything that's already been done with their data. And in some cases, removing data could compromise the study. So HIPAA allows revocation to be limited when it's necessary to protect the integrity of research. I personally learn by using analogies. So think of it like this. It's like trying to take chocolate chips out of a cookie after it's already baked. At a certain point, a cookie is a cookie and the damage is done. Recruitment is one of those areas where HIPAA can feel a little tricky. Providers can talk to their own patients about research opportunities, and HIPAA treats this as part of normal care. But once you step outside of that relationship, things do get a little stricter. You generally can't share PHI with outside researchers unless there is an authorization or a waiver in place. HIPAA does give us some flexibility though, and it's called preparatory to research. This allows researchers to look at PHI to figure out who might be eligible and even reach out to those patients, but only if the information stays inside the covered entity and the activity is approved by either the IRB, privacy board, or a privacy officer. The big rule here is that PHI can't walk out the door during this stage, so recruitment is absolutely possible. It just has to be done carefully and with the right approvals in place. Retrospective research has really grown as electronic health records and big data repositories have expanded. Even though the information is already sitting there, HIPAA still applies whenever PHI is involved. That means researchers need either participant authorization or a waiver or alteration from the IRB or privacy board. In some cases, the data was originally collected with permission for future research, which make things easier, but in most cases, we can't just wander through patients' charts because something looks interesting. Even early exploratory work needs oversight. The big takeaway is that retrospective research is absolutely allowed. It just has to follow the same privacy protections as any other research that uses PHI. The security rule works alongside the privacy rule by focusing on how PHI is protected. It requires administrative, physical, and technical safeguards for any electronic PHI. Every organization must designate a security official who oversees these protections. HIPAA also has strict breach notification requirements. If PHI is exposed, the organization must notify affected individuals and report the breach to HHS. If more than 500 people are affected, the breach is posted publicly on the HHS breach portal. State laws may add additional reporting requirements. For researchers, this means we must handle PHI carefully and understand our organization's security protocols because breaches have serious consequences. So Nicole and I have decided on an article that will expand on some of the information presented today. And we have also formulated 3 questions related to this information in our presentation. But specifically for this slide, I just want to wrap up the information that we presented. I will start by saying that HIPAA adds important privacy and security protections to research involving PHI. While the rules can seem complex, multiple pathways allow researchers to assess data responsibly through authorizations, waivers, de-identification, or limited data sets. The key is understanding which pathway applies and working closely with the IRB, Privacy Board, and privacy and security officers. Ultimately, HIPAA is designed to protect participants while still enabling meaningful research. When we follow these requirements, we support ethical research practices, maintain trust, and ensure compliance across our organizations.
Lisa and I was able to find an article from the HIPAA Journal regarding some changes to research in 2026 in regards to HIPAA. There is a link to the article for you to read in its entirety at your convenience. There were not much of a big difference with research changes in regards to HIPAA, but here is a summary of what was written. Researchers must continue to follow strict guidelines when accessing PHI, including obtaining patient authorization, securing Institutional Review Board (IRB) or Privacy Board approval for waivers when authorization is not feasible, and ensuring appropriate safeguards for electronic protected health information. These updates also highlight the growing emphasis on stronger cybersecurity protections for electronic health records, which directly affects how research data containing PHI must be stored, transmitted, and protected. Overall, the proposed changes seek to balance facilitating healthcare research and innovation with maintaining strong protections for patient privacy and data security.
So I speak for Nicole and myself that we are extremely grateful for you tuning in to view our presentation. We both understand that the city program module was a bit lengthy, so the fact that you've exhausted more time to expand your knowledge on research and HIPAA privacy protections with us, we are extremely grateful. So in closing, we have our 3 questions here, and we will also post them within the Packback module. They will be based around ethical balance in data use, authorization versus minimal risk, and limits of de-identification. If you have any questions or need to reach Nicole or myself directly, please feel free. Otherwise, that sums up our presentation. So again, thank you for tuning in, and please reach out with any questions.